Extradition, international law. Now, what is definition and meaning of the term extradition? Now, against comes Oppenheim. According to Oppenheim, extradition is delivery of an accused or convicted individual to state on whose territory he alleged to have committed or to have been convicted of crime by a state on whose territory the alleged criminal happens to be for the time being. Under international law, extradition is mostly a matter of bilateral treaty. There is no general duty of state in respect of extradition of criminals. So, extradition means a delivery of accused from one state to another state. Suppose a person of Indian origin commits a crime over here and moves to certain other company, say USA or any other country. Now, the government of India can request for extradition of that person, and if America government gives that person to Indian government, that will be known as extradition. But extradition is a bilateral it's a bilateral treaty according to international law. There is no general duty of state in respect of extradition of criminals. So it purely depends upon the bilateral treaty, and there is no general duty. One thing peculiar about extradition is non-extradition of political crimes. It is well-established principle of international law that persons accused of political crimes are not extradited. Although sometimes a problem arises as to what is a political crime. The practice of non-extradition of political crime began with French Revolution in 1789. Later on, other states followed the practice. So, in case of political crime, you cannot extradite. The extradition is generally in case of criminal. If there is a crime has been committed, which is not a political crime, then extradition is possible. And in modern period, all the states recognize this principle. So what are the essential of extradition? The well-established principles that the person accused of political crime are not extradited, although there is a controversy as to what is political crime. This is first. Second, person accused of military crime are also not extradited. Third, person accused of religious crime are also not extradited. So political, military and religious crimes, they are not extradited. Fourth is the rule of speciality. When an accused is extradited, then receiving state must try him for that specific offence for which extradition was sought for. Now, if there is an extradition and accused have been extradited, then the receiving state cannot enlarge and he has to try only for the specific offence which was extradition was sought for. Second was double criminality. The specific offence for which extradition is sought for must be an offence in the state requesting for extradition and the state extraditing accused. So it should be crime in both the states. If it is not crime in both the states, if suppose a particular thing is crime in India and it is not a crime in USA, you cannot ask for extradition then with USA. It has to be crime in both the countries, and the crime shouldn't be political crime, military crime and religious crime. The another is Prima Facie case. The court observed that to constitute a Prima Facie case in extradition case, the following requirements are essentials. Pehla, witness should be entitled to reasonable degree of credit. The degree of proof should be higher than ordinary criminal prosecution. The evidence must be incontrovertible, leading to the probable and strong presumption of offence against the accused. So, though the person is not guilty, but there should be a prima facie case. and a strong prima facie case. A case where it should be very probable and strong presumption that there is an offense against accused. A formal request of extradition is necessary, and there are certain formalities which has to be followed up. The condition mentioned in extradition treaty and other formality must be complied. When a person is accused of having committed a crime and his extradition is sought for, it is not necessary that the accused must be present in the state where alleged crime was committed. 10th is bilateral treaty. Extradition is generally a matter of bilateral treaty. It has been held there must be a formal treaty, not simply an agreement or notification. This was held by a first-class magistrate in New Delhi in Taraso extradition case 1963. Now, what are the example of extradition? Sucha Singh case. Sucha Singh was accused of having murdered Pratap Singh Khera, who was the former Chief Minister of Punjab, and he ran away to Nepal. The government of India requested Nepalese government for extradition. The government of Nepal started proceeding against Sucha Singh, and after being satisfied, there was a prima facie case against them. The Nepal government extradited him. Second case is Dharam Teja case. Dharam Teja was a managing director of Jayanti Shipping Company. He was accused of having embezzled and bungled crore of rupees, and he ran away from India. In order to escape his arrest, he ran away from one country to another. When he was in Ivory Coast, the government of India requested for extradition. As there was no extradition treaty, the Ivory Coast government refused. Later, Dharam Teja went to London. The government of India requested British government to extradite him. The British government started proceeding against Dharam Teja because it was satisfied that there was a prima facie case against him, and it extradited him in pursuance of extradition treaty between two countries. Subsequently, Dharam Teja was tried in India and was convicted of several charges. So, extradition, one thing more, extradition is a huge favor. It's a matter of bilateral treaty. There has to be a bilateral treaty. Then only a person can be extradited. There should be a formal request. There should be a double criminality. There is a rule of speciality. Means the person can be tried only for the specific offense. He cannot be tried for political crime. He cannot be tried for military crime. He cannot be tried for religious crime. And if, say, Indian government says that we need this person for a bomb blast case, there may be 5 more cases pending against him, but you can try that person in only that case. So there is a rule of speciality. And double criminality, it has to be criminal in both the countries. And there has to be a extradition treaty, because it's a bilateral treaty, a bilateral matter in the international law. Thanks.